Well, welcome. Welcome, Nina. Welcome,
Morning,
Matt.
Andrew.
How
Morning,
about this?
Nina. Yeah.
Okay, well, we're back
No
on
problem.
board. We're back in the huddle. This is actually the team.
Yeah, I'm
That
on
is
board
not
with in the
our
huddle.
hashtag.
Oh, we've been debating it all week. I think in the huddle
Oh.
works, Andrew.
Yeah.
I'm with you on this
Well,
one.
I'm the boss at work. Okay, so look, we've got some really interesting stuff to talk about. We do have some news, some really interesting newsworthy things, but we're also going to look at two particular things. One, sadly, we're going to talk to you about COVID again because we actually have to, because it is news and it is really important news. But we'll look at it in the context of safety and this emergent trend with both regulators and courts in sending people to jail. So for people who aren't officers in the room but are advisors, this gives you a real picture of what is an officer and where their liability arises. But look, let's just kick off, Matt. Federal government, family and domestic leave, talk about that.
Yeah, that's right. So legislation, or the bill, sorry, put up in yesterday.
Yep.
10 days paid. Where it's most interestingly, I think, departed from what we all understood it was going to be. Permanent, full-time, part-time, and all casual employees entitled to it.
So to the extent that they would work on that roster.
That's right. Yeah. So if they had a rostered shift on and then they needed to access the leave for family and domestic violence reasons, they would be able to do so for that particular day. Everything else sort of has stayed the same with what we expected, so it doesn't accrue year to year. The notice and evidence and requirements are the same. But look, a really interesting shift again, something that we talked about this morning, Andrew, about the Labor government's approach to the casualisation of work, increasingly looking to sort of take away some of that casualisation by extending entitlements that would have otherwise traditionally just been for permanent employees. And this is the latest
And we've seen
example.
it from the Victorian government who started this process.
That's right, the sick pay guarantee.
Now it's going deep into the federal government in all the changes.
That's right. I think we'll see it more and more over the next couple of years. So different types of leave coming through, the casual.
And I think we'll see that emerge right into the gig economy as well.
Yeah, absolutely. Absolutely.
All right, well, that's great. Well, I think we're going to go to you actually before we go to Matt on the case. Okay, so the Northern Territory positive duty. Talk about that.
Yeah, so they've followed in Victoria's footsteps and are planning to introduce a new positive duty into their Anti-Discrimination Act, which will require employers to proactively take reasonable steps to prevent sexual harassment, discrimination, and victimisation.
And isn't this interesting when we've got now 3 jurisdictions who are looking at psychological injury as either regulations or codes? Isn't it good to see legislation starting to harmonise across the different parts of workplace?
Oh, absolutely, Andrew. Yeah, I mean, we've spoken on this many times about how frustrating that can be for clients out there.
Yeah, well, the three of us sit across over 62 pieces of legislation that affect workplace law, which is really the differences that sit between state jurisdictions in things like discrimination law, safety laws gradually harmonising, which is great. Except for Victoria. And except for Tasmania. And New South Wales when it comes to industrial manslaughter in South Australia. Who's thinking about it? But other than that, we're very similar. Okay, Matt, I reckon. I know you put this case in, that's just because you want to rail about it. This is about the unregistered union and Woolworths. Yeah. And perhaps we don't know the full story in this case.
No, we don't.
This is an adverse. This is a lay down misere adverse.
It is.
And nobody knows why it happens. But there's got to be another story.
No, that's right. Look, a really fascinating case, very timely and topical in terms of what we'll be talking about today. But Woolworths engage in adverse action against an employee. The employee, a union member of an unregistered union, we assume, because it's not in the facts, probably someone who's a little bit vocal in the workplace, probably raising complaints about things all the time, actually raises a quite legitimate complaint about lighting in a car park at night time. So very clear safety-related complaint. Within days of the complaint being made, Woolworths actually goes, well, actually, geez, this is pretty unsafe. They do a risk assessment. They go, let's turn the lights on.
Just remember, before that, they'd threatened to move it to another area.
Yeah. Well, that's right. Well, So, and in the interim, no, that's the thing. So, I mean, to emphasise, they acknowledge the safety complaint, but then they just kick this poor woman while she's down, really. They threaten to move her to a different department. They direct her to a performance-related meeting to discuss a whole bunch of things, including the fact that she raised this complaint. So, look, clear adverse action.
So somebody's sitting there, aren't they? They're going, I just can't stand it.
It's
regretted no, another complaint.
And look, we get calls from clients of this all the time, in fairness. But the difficulty is sometimes you get people like this, and they do raise a whole bunch of sort of unreasonable complaints. But you've got to look at each one.
And you're
independently.
sensitised to them because
Yeah,
they just.
yeah.
We're not saying to this poor woman who's out there that she's crazy, but there are times when
Yeah.
you have the red flag employee who just go
Yeah.
and the end just go whack, and they say something. You go, that's it, line in the sand.
That's
Let's
right.
deal with this.
Yeah,
But they've raised a legitimate one.
that's right. That's right.
They paid $10,000 penalty.
They did. So look, they admitted to the adverse action before the court. They paid separate compensation to the employee, gave her a written apology and everything. But there was a dispute really about what the penalty
No
would be.
discount on goods though.
No, no.
So prices weren't going down.
No, they didn't scare
Penalties were going up.
Didn't scare the
No
everyday
warning in the
rewards.
green
No,
room about that joke, was there?
No, we weren't prepared for that one. No scanning the everyday rewards. No flybys on that one. 10K straight out, straight paid to the union. So look, I think a great example of a lesson about yes, you might have these employees who are raising lots of different things that are annoying, but when you get a legitimate one, particularly when you're going to act on it so quickly, take a step back and think, breathe. Is this something that we actually need to agitate around? And I think that's
don't set and forget.
Don't set and forget.
Just thought I'd get that in for Matt before he could say it later.
I told them it would come up.
Yeah. No, so let's, now that we've dealt with that case, because that was a bit of fun, let's get to the heart of what we're talking about today with Nina. And what we're talking about today is we are seeing a trend that's coming both from regulators prosecuting to courts taking them much more seriously and imposing more than just fines for serious stuff, imprisoning people around officer conduct. So the first thing is, let's just define what an officer is so everyone gets it. Because it's a funny sort of name.
And it's also something that's really misunderstood, I think. Me and Matt were chatting about this morning, but everyone knows, look, officers are directors and secretaries, but what they don't realise, it also extends to anyone who makes decisions which would affect the whole or a substantive part of the business, or anyone who could affect the financial standing of a business as well.
So that's your executive group.
Yeah.
Particularly your CFO who says, look, I'm not going to fund safety things. Okay. So there's quite a large group of people who are actually officers of business. And the first thing you must do is actually identify who they are, make sure your officers and directors policy, insurance policy covers them to the extent, I know they can't be covered for safety prosecutions now in a number of states and jurisdictions.
Yeah, that's right.
But once you know who they are, then we come to the next question, which is, what is happening when what are the things that officers can be liable? And there's three things, isn't there? There's a primary duty breach.
Yep.
Now that's because we're in Victoria. It's slightly different in Victoria to elsewhere. What's the difference?
Oh, yeah, this one's an interesting one. So Victoria has a higher threshold for officer liability, which is super bizarre. An officer actually has to know about the hazard to be prosecuted for it. So an interesting example, Andrew, is we've been moving offices in Sydney this week.
Thanks for listening.
And whilst during the moving process, I want to make that very clear, no one was aware of this risk before. One of I think the contractors identified there was a live wire, and they informed Andrew, and of course things are being done to fix it. But what's really interesting is if he didn't know about it in Victoria, he just could not be prosecuted if no one told him. Yet in New South Wales and everywhere else in Australia, he would be found liable regardless.
It's crazy, isn't it? Such a strange distinction.
So that's section 144 in Victoria, which actually requires subjective knowledge of an officer. It's one of the things that Victoria oddly didn't move on during the harmonisation process. In fact, it's one of all of the things that Victoria didn't move on. It refused to harmonise at all.
That's right.
But anyway, that's a different issue. So we know the primary duty breach.
Wait, before we move on, I just want to say though, it doesn't give you a free pass like officers in Victoria if there are obvious risks. So things like COVID, which we're going to talk about later, traffic management, fall from heights, things that are obvious. Mental health.
Yeah,
things that are obvious to any reasonable person, even if you're not directly informed about it, you should be aware that risk exists and do your proper due diligence.
So don't be an officer who says, don't tell me that.
Willful blindness doesn't get you over the line.
No, but the important thing is it has to be attributable to.
Yes.
So in other words, it's the officer's behaviour has to be a causative factor in the process to get the officer liable. But then things get a lot worse, don't they? Because you can officers.
It's going to keep getting worse today.
Officers can be liable like anybody else for
reckless conduct,
and only officers can be liable for industrial manslaughter, which is in every other jurisdiction
except New South Wales. Tasmania and South Australia.
South Australia is coming to the party.
Mhm.
Yeah.
If there's such thing as a party around industrial manslaughter.
Oh,
Anyway,
I thought you were about to say in South Australia, Andrew.
gone too far. Mentioning Deputy President Deans. Okay, so reckless endangerment, quick definition.
Yeah, so it comes down to two things. Subjectively depends on what they knew.
So it's a knowledge of risk of serious injury or death, yeah.
And then the objective thing is whether they were careless and how they handle it. So the most common thing we see is people will deal with it in some way, usually an administrator of control, and think, look, I've dealt with it, that solves the problem. That's not enough. You actually have to apply the hierarchy of controls. And if you do not apply enough that is reasonably practical, you'll still be found guilty of reckless conduct.
Yeah. So it's interesting, isn't it? Because we commonly see an officer say, well, look, surely we can do something about it. The safety guy goes, yeah, it's a big hole in the floor. It's pretty dangerous. It goes down 10 stories. We can put a bit of masonite over it and you can put a sign, but it's not really enough.
No.
And the officer, yeah, do that. Just do that short term. We'll fix it later. That's reckless because they were aware of it. They're actually aware of this high level risk, and what they did was insufficient to fix it. So that's
careless.
Which is careless.
Yeah.
Industrial manslaughter. Unfortunately, and we're going to give you a general definition because there's 3 different definitions that exist. But the primary definition is that there is a high risk of death.
Injury, death.
Yep. That there is a breach of a primary duty because it has to be attributable to safety.
Yeah, that's
we're
right.
talking about. And then it must be grossly negligent.
Yeah, by the officer.
Yeah, and then it must be death.
Yeah, and directly linked.
Yeah, but it doesn't have to be death on site.
No.
So when we're talking about industrial manslaughter, have a think about the types of things you have for industrial manslaughter. Mental health's the obvious, that people can die of.
COVID now.
COVID is a really obvious one.
Right. Yeah.
So all of those things, officers can be liable, and we start to look at the case law. So we have ups and downs in case law, don't we? But so let's look at a really low level risk for reckless endangerment for an officer and see a court's response in Aussie skips.
Yep, that's right.
No, I know it's right. That's your actual hint to talk about the case.
Yeah.
Aussie
skips.
Okay, so
Sophie, can we cue her?
So Safe Work New South Wales and Aussie Skips basically involved a case where a heavy truck rolled into a worker as they were picking up garbage material.
Picking up the rubbish by hand.
Yeah. And they were directly supervised by one of the supervisors, and he had, basic controls, was watching what everyone did, but he was still charged with reckless conduct and fined $60,000 because they found, although he did the minimum level of controls, he failed to do risk assessments. He didn't ensure that policies were enforced. Look, they didn't even have proper traffic management policies. The way to let pedestrians know that there were vehicles around was verbal instructions. So there was just real absence of taking all reasonably practical steps, and that was enough to find them guilty of reckless conduct.
Yeah. So the point here is, failure to do everything reasonably practical is a primary duty breach, okay? But where you have knowledge of something which is such a high risk, and where you're doing just a little bit along the way, but actually it is careless because you can see the risk materialising in front of it and you do nothing about it, it's reckless endangerment. Very low level compared to some of them. So in orbit drilling, we see a next level up.
Yeah.
In orbit drilling, which was a case where a truck was not fit to be driven, where the braking systems failed. A young boy had never been
very
shot.
inexperienced.
This boy never been given
10 days he had his license.
Then drove down a steep, muddy hill in dangerous circumstances. Brakes failed, rolled, kid died. Managing director in that fined incredibly high. This is very first reckless endangerment case run in Australia and Victoria.
First big one, yeah.
The organisation itself got a fine that was only $120,000 less than the maximum fine, and the supervisor got a suspended sentence. And that was probably the first warning across the bows to everybody. Now we won't go through all the cases, but there's cases like Watts and a number of other cases where you've seen this gradual escalation of penalty coming each time. And we've now had a number of people sentenced to jail who are either supervisors or officers across Australia. So I guess for the 3 of us, when we started talking about this, is that the most recent case that came through we saw synergy is a
Yeah,
case
that's an
which
interesting
in
one.
any other jurisdiction but New South Wales and Tasmania, maybe a bit of South Australia, but this would have been an industrial manslaughter case. So only could be reckless endangerment. It's a case which Nina will tell you the facts in a second. But the really interesting part of the case is reckless endangerment was charged. The principal contractor got a $900,000 fine, which is a massive fine.
Huge.
Under what's called Category 2 reckless endangerment, which is 1.5 million. So it's the very upper level. And yet they'd actually done some good things.
Yeah.
So Nina, maybe just a brief summary of the facts, and then we can talk about the charge against the actual, not individual, the skipped, what is the business name?
Synergy.
Synergy.
Yeah.
Has the charges have gone in. We haven't been heard yet.
Mm.
No, they've just been charged.
Yeah. But it's fascinating because when you hear that, I want you to remember the definitions and say, why doesn't New South Wales have industrial manslaughter? So off to you.
Yeah, so in Synergy, there was an apprentice and another worker working underneath scaffolding, which was 13 levels high. The scaffolding collapsed on them, and unfortunately, I think one of them died. What was really interesting is the principal contractor in this case was aware that other trades, so not Synergy itself, had been undoing the ties for the scaffolding because they were progressively dismantling the scaffolding. So they had raised that with Synergy and said, look, can you make sure that you do daily inspections just to double check because people keep undoing these ties. Synergy just never followed through on that, and everyone was rushing the construction. They were overloading the scaffolding with pallets of bricks. So essentially, I think the judge in this case said, look, the risk was so obvious. The incident was basically bound to happen. Like there's just no.
Wow.
So can we go back? So the principal contractor was reckless endangerment.
Mm-hmm.
Why? Because they knew there was a high risk
Yeah.
of serious injury or death. They were actually alert to some of the factors that would cause that.
Mm.
To the extent of their supervisory responsibility, all they did was give a direction.
Yeah.
Rather than once you're on notice as a principal contractor, you must be satisfied there's a system in place and correction has occurred.
Mm-hmm.
Then you must do an audit process to do it. They didn't do any of that, $900,000. But what about Synergy? Synergy, we're told, there's people not doing this correctly.
Yeah.
This structure is unsafe.
Yeah.
They were told it.
Expressly told.
They expressly told it. Okay, so let's just go back to definition of industrial manslaughter. High risk of serious injury or death,
Mm-hmm.
a notoriously high risk because working at heights.
Mm.
Okay,
Yeah.
so
Obvious
very high
risk.
risk. Clear breach of primary duty, and the issue of criminal negligence comes to bear because they had a duty to ensure this was safe. They were told it wasn't safe, and they did nothing.
Mm.
Yeah, the base level also wasn't safe because Safe Work found out 50% of the scaffolding they had erected was not compliant anyway. So it was double unsafe.
So I'm
crazy.
raising this now. If this was in Victoria, there is absolutely no doubt.
Oh.
Not only would there be industrial manslaughter, but the officers involved would be in deep strife because
Absolutely.
they were aware.
Mm.
They were aware. So look, fascinating case, and let's flick it into COVID. Now, I'm sorry to talk about COVID, and I've promised I'll try and avoid COVID cases for a while.
COVID again, I love that.
Yeah. But, 47% of Australian adults have had COVID.
Mm.
We've got hospitalisation rates at a level equal to the worst time during COVID. We're now opening up other wards to take on people who are in the middle of winter.
Yep.
The infection rates under the new whatever it's called.
Variant.
Subvariant. Thank you for that.
That's
because
all right,
I've run out of COVID language.
Yeah.
It seems to be more transmissible, but also has slightly more serious effects and is harder to treat.
Yes, that's
So
right.
that's the truth.
Yeah.
Now, you probably saw from our LinkedIn post, we did that risk assessment. We went and changed the way we work. We did it because we're a good employer, hopefully, but also because we totally understand what the legal ramifications are. When a risk changes, you must do a fresh assessment. And from that assessment, there are things you do. So, Nina, you're our safety guru. Nina.
No.
Please don't call me that.
Yes. Guru in the huddle.
That's right. Guru in the huddle. That's
Gurus
right.
in the huddle works. Yeah.
So
Get that
Nina,
hashtag going.
what are the things when you've done the risk assessment? What are the obvious things that you're going to start doing?
Well, for one, please ensure that you're actually enforcing any policies. Like you should be updating your COVID policies. Things have changed. If you're having people work in the workplace, are they maintaining social distancing? Are they wearing masks? Are they ensuring they're not coming to work if they are sick? It's all too common. We say, I'm going to use Matt's phrase.
Yes, I
We
was
see
waiting
people
for it.
Can we wait
implementing
for the
these
two together?
policies,
One,
and then
two,
not
three,
really, so
and
set
set
and
and
forget.
forget. That's right.
Yeah. And look, what
And I
WorkSafe
said I'd never say that.
Twice.
today.
Twice in 30
Oh my
minutes. What a
gosh.
good run for this.
But what WorkSafe have made very clear is they're not going to turn a blind eye to COVID anymore. Like the 2 years of free for all, look, people getting used to it, employees didn't know what they had to do. All of that's gone now. And now, if you get an outbreak in your workplace and someone gets seriously affected, WorkSafe will be on to you if you haven't had the sufficient controls. And the officers, particularly.
And look at reckless endangerment.
Ah,
And I think what the three of us have talked about and what we've seen is, nobody has done a fresh risk assessment.
no.
Okay. So you have no defence.
That's right. Yeah.
Secondly, to the extent they do have policies, and those policies could help because they haven't been reset, to the extent that has occurred, they're still not being enforced.
Yeah.
And that's something the officers are aware of in Victoria because they're in the workplaces seeing people breach it.
That's right.
And they've been told that Australia's lost its interest and isn't complying, and therefore their knowledge is, what is it that we need to do to induce people to comply? Is it being more threatening? What is it we have to be to make sure that people comply? But they know that's the risk.
Yeah.
And you can't hide from it. You can't say, look, I don't know that, because it's across the media that Australians are not complying. And if you get on a tram in Melbourne, what do you notice? Half the people who are obliged by law to wear masks are not wearing masks.
That's right.
So,
the government regulation, it's gone.
Yeah.
That's the thing. There's that misunderstanding that, look, if the government's not enforcing it, we don't have to. But it's now your problem.
That's
because
right.
the government's not stepping in.
Almost exclusively your problem as an employer and as an officer now.
And WorkSafe have made that extremely clear.
Yeah, by prosecuting a poor bewildered casual nurse because they don't have the judgment not to do it. Anyway, that's another issue. But I want you to think now, I want you to go out and say, is our risk assessment up to date? No. I'm going to do it. Look at the advice that is around about what you should do. Feed that into your risk assessment. Go back to your policy and the directions to employees. Make sure that you train all your supervisors and leaders, and then have an audit system to ensure it's happening where there is disciplinary action that follows where it doesn't.
And make sure you consult. We've heard that from so many employers where they've just implemented these changes and then not consulted the employees, so they're not aware of key information which could affect it. So please do it.
Please consult.
Now that is the end of our COVID rant.
Yeah.
Okay.
For this week.
We're all fully vaccinated, and good luck. Okay, so let's go on to the case study. And Nina, it's your reading today.
Yeah. So Jeannie was a manager at Cat, Bird and Parrot.
That wasn't what I said. I can't believe, Sophie, you changed that.
Oh, the editorialising
She's
here.
doing it again.
Yeah. You're being sensitive. Yeah, sorry.
CVP, a first-year accounting firm in Melbourne, she reported to one of the partners, Gideon, who was an eccentric yet highly skilled tax accountant. Gideon's work practices were chaotic. He committed to unachievable deadlines with his clients and threw last-minute instructions to Jeannie, who would end up at the brunt of the criticism from the client. Gideon persisted in having early morning and late night meetings, even though he knew Jeannie was a single mother with 2 children under the age of 5. On the flip side, Theo, who was the same age and status as Jeannie, was given the cream of client work. Gideon allowed Theo to set his own deadlines and positively supported him with clients. At 8 p.m. on Friday night, Gideon rang Jeannie at home, needing her to prepare a document for a client by 9 a.m. on Saturday. Gideon knew Jeannie had worked over 70 hours that week, and this was a task he should have arranged 2 weeks before. Jeannie worked through the night to complete the work whilst also caring for her children. The following day, she was exhausted and couldn't stop crying. She felt that her life was out of control and she couldn't handle the thought of returning to work. On Sunday morning, Jeannie called David from HR, who was not surprised at what Jeannie told him, confirming that everyone had noticed and was concerned about how stressed she was. David told her to take Monday off to rest and reassured her that he would speak to Gideon with the support of the managing partner, Vicky. Vicky was incensed that no one had told her about Gideon's behaviour. She reviewed the time recording and spoke with other Melbourne partners who all agreed that he treated Jeannie unfairly. Despite Vicky's anger, she didn't intervene in any way, seek an investigation or take any action to protect Jeannie, except saying to David to tell Gideon to be gentle with Jeannie and keep an eye on her. When Jeannie returned to work on Tuesday, Gideon called her into the office, calling her a silly girl for complaining to HR. Gideon said he had given her the best opportunities for growth and advancement, but now his hands were now tied and he would have to give all the complex, interesting work to Theo. Gideon then gave Jeannie 4 matters, all behind in delivery because of him, and said he needed them finished by the end of the day, an impossible task. Jeannie left his office and went downstairs in the lift to get some fresh air. As panic took over her body, Jeannie wandered onto the road without looking to see if there was any traffic, and she was struck and killed by a truck.
Sad story.
Yeah, it's real dark.
I
it is
reflected
a bit
on this
dark.
very dark.
Yeah.
No, it is dark. Yeah,
Dark.
yeah. It was after family dinner.
Oh my
All right, so we've got a minute now, so
Yeah.
download Slido.
Yeah,
Yes.
Please.
scan the QR code.
Yeah, or scan. Oh, that's right, or scan the QR code.
We're gonna
No
have
one
to start.
downloads anymore.
No, that's
Go
right.
with the time.
Yeah, it's like you didn't spend the last 18 months
This
scanning
is
QR
why-
codes.
Yeah.
This is why it felt dark.
I'm just saying, with the shift to the case study at the bottom, I think the three of us are all going to have to think a little bit more about how our faces present while we're reading it
That's
out.
right.
Yeah,
We looked very seriously
true.
concentrating.
I
there.
was seriously concentrating.
Yeah, well, it
because
was. It's a serious
none of
matter.
those were my words.
Oh, that's very fair.
Because Sophie's stolen my language.
Yeah, that's right. Well, now you've got flip side.
And
You've
put
vocabulary
in
codes.
earth language.
Yeah.
I had words in there that I knew couldn't
Yeah.
be said
That's that's true. That's true.
because I knew Nina was reading.
Yeah, exactly. You like to keep Soap on her toes. Yeah.
Well, she's destroying who I am.
They're the production manager in play.
Yeah, I know the production manager's killing me.
That's true.
All right. Okay, lock in those answers. All right. So, could Vicky be charged with any breach of the Occupational Health and Safety Act in Victoria? So
Yeah.
the answer is yes.
Yes.
And
Yeah.
the answer is
Definitely.
every single one of them.
Yeah, she's definitely an officer,
Yeah.
undeniably.
Yeah.
And I think most interesting with reckless conduct, she did a bit, but as we know, a bit's not enough.
That's
It's not going
right,
to cut it.
Right. The failure to do the investigation, to
Yeah.
take any of those
Or
steps.
to just provide some room.
Oh, that's also
You know,
good.
like
yeah.
this is a classic example when you've got a complaint where someone is quite clearly belittling, hurting, and placing a
Yeah.
work burden on. We look at the psych regs, which still aren't in, but when they come in, this is exactly the types of behaviour it
Yeah.
contemplates.
Absolutely. Absolutely.
And of course, the reporting duties and the ones of discrimination and harassment. We talk about that down the bottom, but this is clearly harassment at school.
Oh,
actually.
yes. Yeah.
And he's clearly treating her very differently
Yeah.
to
Yeah.
Theo.
That's right.
And she's working incredible hours. And
Yeah.
some of the facts that have disappeared from Sophia are she's working a lot harder than Theo as
That's
well.
right.
Yeah,
Yeah.
that's
Yeah.
right.
And has more
Yeah.
people to supervise Sophie, which wasn't a problem.
Yeah.
But anyway, so yes, definite, whether you're looking at a primary duty breach in Victoria, she had knowledge. Everywhere else, she ought to have had knowledge. Next question, so we've got that breach of primary duty. We've got high risk of injury or death. It's a mental health issue.
Absolutely.
Yeah.
No, so very high risk. We've then got for reckless endangerment, well, did she do anything that related to what you would think you would do? No, she just handed to somebody
Yeah.
in an ineffectual direction,
Yeah.
which left the person
Yeah.
exposed
Tried
to
to
Didn't follow
delegate.
up on it or
Yeah.
anything,
Tried to
yeah.
delegate her duty.
and of
yeah.
course, unlikely industrial manslaughter, but the fact that Jeannie died off site doesn't matter for industrial manslaughter. So the difficulty is gross negligence, and I think you'd have trouble proving.
Yeah.
Okay.
Yeah.
All right. Could Gideon be charged with any offence under the Occupational Health and Safety Act?
Oh, yeah.
Yeah. Yeah.
God.
Although interesting argument about his role as the partner in the partnership.
Yeah. So definitely everything. The issue is
Industrial
whether he can be an
manslaughter,
officer for industrial manslaughter, and
Yeah,
that goes to the
absolutely,
partnership deeds, which usually delegate the responsibility, control, and management to other people, but could be charged. Technically, just on the legislation, could be.
Yep.
Could David be charged with any offence under the OHS Act? Now, I put this in because safety people and HR people think they're immune. Okay. And there are a whole lot of cases which deal with underpayments and wrong characterisations.
Yeah,
which say
absolutely. Yeah.
where a person, because of their skill, has knowledge of what is the correct thing, fails to advocate it, and allows it to occur with their knowledge, then there will be liability. And exactly the same sits under Section 25 and its comparators across all jurisdictions. So the answer is yes, David could be charged. And that's a warning for all safety and HR people out there.
Yeah.
When your people are doing things that you know they're wrong and you don't advocate against it and document that you're doing that, you could be liable.
Absolutely.
And really, Matt, just coming back to you, I guess.
Yeah.
Discrimination, and worse than discrimination, victimisation.
Absolutely.
Mm.
I mean, absolutely, yes, is the answer here.
Yeah.
It's unfavourable treatment. The motive here, whether he was motivated by just wanting to, who he thought was the better worker, is irrelevant. It's clearly based on her gender, based on her family and care and responsibilities.
Early, late meetings. All
Of that sort of stuff.
But just explain what victimisation is in 10 seconds, will you?
Well, that's right. So it's 10 seconds. All right. So it's
That's what you got.
taking a retaliatory action against someone because they've raised the complaint or made it. Yeah,
And is the money claim.
It is.
It
That's
is
right.
the money claim. So
It
if
is.
she had have lived through this,
Yeah.
The discrimination claim would have
Yeah.
been a very powerful. We were talking millions
Yep.
in this sort of thing.
That's right. The
Because
silly girl comment and the telling her off.
That's
to go
it.
to HR.
It's time. It's time. Thank
Yeah.
you very much. Thank you for joining
Yeah,
us.
thank
Thanks,
you.
Andrew.
We love having
Give
our
us a
friends come
like.
along.
Please
see you
like
later.
and react,
Yeah,
etc.
all those
those
reactions
things.
we want.
Yeah,
Okay?
all of them. Each
All
one.
of them.
Each
See you
time.
later, guys.
Bye,
Bye-bye.
everyone.
I've never seen Matt